Welcome to Division 5 of the Court of Appeals. I'm Michael Berger. To my right is Judge Gilbert Roman. To my left is Judge David Richman. We have 4 cases this afternoon, 2 on our 1:30 docket. The first is People v. Nooner. I assume counsel are set up for that?
Yes, Your Honor.
And the second is Newcastle Properties versus Connecticut Realty. Are counsel ready for that?
Yes, Your Honor. Yes, Your Honor.
And then the lawyers don't have to be here yet for the 2:30 cases, but let me find out if they are here. We have Stewart versus Wu. The lawyers here for that?
At least one of them is
Well, one of them. It should be an easy argument for you then. And Houchin versus Denver Health. Any lawyers here yet for that one? Okay, we'll take that up at 2:30. As I'm sure you know, we live stream and archive these arguments, so please be careful. I think in the first case this may be applicable. If either court policy or the law requires you not to use the name of certain persons, please don't use the names because once you say it, it's there and there's not much we can do about it. If you have a phone or any electronic device that can ring or beep, please turn it off. The tech people tell us that airplane mode isn't good enough. For some reason, it still interferes with our recording system. So please turn it off. Each side has 15 minutes. The appellant may take any amount of that time to reserve as rebuttal, but it's up to you. You have to manage your own time. We don't manage your time. And I'm hoping that all of the counsel are familiar with our oral argument protocols.
Yes, Your Honor.
Do you have any questions before we proceed to argument?
No.
Okay, well, with that, then let's proceed with argument in People versus Nooner.
May it please the court. James Hardy, attorney number 38173, representing Justin Nooner. I will focus my remarks today on MC's identification of Mr. Nooner, which is issue 2 in the briefs. MC testified that she saw the same man on both days in question. She said Justin Nooner was that man. She said she later viewed Mr. Nooner's photo on Facebook. Defense counsel asked to approach the bench, and the court refused and released the jury for the day. 16 hours later, the court instructed the jury to disregard the evidence or discussion about pictures on Facebook and things like that.
Hang on a sec.
Yes, Your Honor.
Something happened during the 16 hours, didn't it? Did the defense make an objection or raise some kind of objection to the identification? The way you just described it, they didn't, but I assume they did.
Yes, I did skip over the, after the jury was released, there were proceedings at the bench. There was a discussion about the pretrial motion that had been filed by the defense asking to have a determination of whether, if the prosecution was going to offer any identification testimony, to have a reliability determination performed. The result of those pretrial proceedings was that the prosecution represented that they were not going to present any identification evidence. And then after the jury was released on this first day we're talking about, they have a discussion about that procedure, during which I think everyone in the court, prosecution, and the defense agreed that the testimony that had just been elicited from MC was improper and shouldn't have come in.
Everybody agreed to that.
And yes,
So now the issue is, what's the remedy?
yes.
Okay. That's
Yes.
about what you're going to tell us, I think, right?
But before you do, let me ask you this. So the 16 hours passes. Is there anything at that point that the judge could have done to have cured the impermissible event that you allege occurred in this case? I guess everybody agreed.
Let me make sure I understand your question, Your Honor. You mean prior to the 16-hour delay or
Well,
afterwards?
once they went home, was that the end of it? Then did we have a defect that could not be cured, and there's really no point in discussing much further about that issue?
I would agree with Your Honor that once those 16 hours pass, I mean, I have more to say about the particular circumstances of this case and what the judge actually did after those 16 hours passed, but the stain is there in the jurors' minds of the identification evidence. And I believe that it would have been, it was an incurable error at that point. Now, I believe the error was then compounded by what the court, in fact, did, which was issue an instruction which didn't actually explain to the jurors what the evidence they were intended to, they should disregard substantively was. The court, in fact, did not tell the jurors to disregard that an identification had been just testified to by MC.
Had there been a mistrial, there was no mistrial motion, though.
There wasn't a motion for a mistrial, that's true. At least in my reading of the record. The parties all agreed that the error had occurred and that some action needed to take place. Now, the defense did ask for the bench conference before the jury was released for the day, and the court cut that off and said no, and then immediately released the jury. So the record that the defense made after it asked for the bench conference is the action that the defense would have requested to be taken immediately before the jurors were released. And the defense did tender a jury instruction with the text that no identification had taken place in this case.
The next morning, they tendered an instruction.
That's right, Your Honor. But given the procedural posture here, had they tendered it after the judge denied the bench conference and released the jury, it would have made no difference because the jury had already been excused for the day. So the critical point, again, is that the court did not instruct the jury to disregard the identification of Mr. Nooner. And the prosecutor in this case said, in closing argument quite clearly, identification is the only fact at issue in this case. Mr. Nooner presented a strong alibi defense. The errors here by the court and due to the identification elicited by the prosecution were not harmless, let alone harmless beyond a reasonable doubt.
So are you saying that if the court, before the jury was released for the day, had given an instruction that the jury was to disregard whatever identification might have been given, that would have cured the error?
I would certainly call that a closer case, Your Honor. The risks of having this kind of unreliable identification evidence come in at trial, I think the danger of unreliable identification evidence is well discussed in your concurrence in the Emanuel Thues-Roberts case. Identification evidence that has been untested, is unreliable, can lead to false convictions. I mean, I think the sciences and the most recent case law has demonstrated that. So when I hesitate to say, would that have just cured the error, it's because this sort of evidence is so damning. And in this particular case, that was the only identification evidence that the jury heard. In a case where identification was the only, according to the prosecutions themselves, was the only fact at issue in the case.
And so there's no way that the error could be harmless beyond a reasonable doubt, despite the jury hearing a testimony of a confession by the defendant and the witness identifying pretty closely the license plate that enabled law enforcement to track down the vehicle and the defendant prior to the confession?
Well, a couple things, Your Honor. So Mr. Nooner's alibi defense was completely consistent with the girls seeing the license plate on the second day. At trial, defense counsel admitted that the girls had seen Mr. Nooner on the second day when they said that they saw a man drive by and glare at them. Defense counsel said that indeed was Mr. Nooner. That explains the license plate, or the close to accurate license plate that they gave to the police. As far as the confession, it was very dubious in this case. The officer testified that he intentionally took Mr. Nooner to a station house that didn't have recording capabilities. The officer admitted that he fed Mr. Nooner the details of the incident in question before Mr. Nooner allegedly confessed to them. Of course, Mr. Nooner did not testify at trial. And finally, the officer's testimony was merely his recounting, his synopsis of what he recalled from several years earlier. I mean, as the court knows, there was a good bit of delay in getting this case to trial. But from several years earlier, not direct statements or, again, recorded statements by Mr. Nooner. So the confession was dubious at best, Your Honor. And so given those circumstances, I would say no, that there was no possibility that this error was harmless beyond a reasonable doubt.
Mr. Hardy, I don't want to derail your argument on this point, but I do want to hear about the sufficiency of the evidence.
Yes, Your Honor. As far as the sufficiency of the evidence, I'll keep it brief. Even under the definition of to invite or persuade that the Attorney General has offered up, which is,
A dictionary definition,
well, I think we have competing dictionary definitions.
but not a case that defines the statutory, not a case that defines a statutory term.
I think that
Entice or
the two cases that are closest to on point, Pfeiffer and Douglas, which are cited in the Attorney General's brief and in my reply brief, they don't, I believe they both rely on plain language interpretations. We have competing dictionary definitions, but I believe even under the Attorney General's definition, which is to invite into the presence, in this case of a vehicle, that requires inherently some intent that the person receiving the invitation or persuasion, some intent that they actually join the person asking in the vehicle.
Suppose the defendant stopped his car. In other words, he made the statement that he was alleged to have made, and then he stopped the car on at least one of the occasions. Would that have been enough?
Well, again, that would be a much closer case. I don't agree if that was the only circumstance that was different and all the other circumstances were the same in this case. I don't agree that that by itself would be enough. I think there would have to be something more demonstrating the intent that the recipient of that of the yelling and obscene remark actually join you in your car.
So if the defendant said, "Come over here," in addition to what he did say, that would probably meet what you're saying?
Well, let me make sure we're on the same page. So this is a fact scenario where the defendant stops the car, utters the remark, and also says, "Come over here," potentially with a hand gesture. That is getting a lot closer to sufficient evidence, certainly. If the court doesn't have other questions at this point, I'd actually like to save the remainder of my time.
Thank you.
Good afternoon. May it please the court. My name is Brittany Limes, registration number 48733, and I represent the people of the state of Colorado in this matter. I'll start first where my opposing counsel started with the identification issue or the curative instruction issue, because at the end of the day, the court did exactly what we would want trial courts to do when faced with potentially prejudicial or inadmissible evidence, which is to sustain the objection, and then as soon as practicable, when the jury came back, first thing the next morning before the victim began testifying again, to say, "You heard some evidence yesterday, referred specifically to what it was, the discussion of the Facebook identification, and say, I told you at the beginning of this case that there will be times when there's evidence you're not allowed to consider. This is one of those instances. That discussion was inappropriate. You cannot consider it. You must act as if you have never heard it, and it cannot factor in to your decision."
But it really wasn't as soon as practicable. That's one of the problems. I mean, the judge could have allowed the record to be made, either send the jury out, and then the lawyers and the judge talk about what needs to be done to fix this. Instead, the judge refused to even allow the lawyers to approach the bench, as I recall. So when you say it was done as soon as practicable, that's not the way I read the record.
I mean, I guess, Your Honor, we disagree on that. I think that trial courts, when they are conducting trials, and particularly scheduling when the jury can go home for the day, and not even necessarily knowing what the issue was that defense counsel was going to raise the objection to, or how long a bench conference would take, I think that especially in this area where the trial court has substantial discretion, and when this court is reviewing for an abuse of discretion, the real question is whether no reasonable trial judge would have done what this judge did, which was saying, hey, we're at the end of the day, this seems like it'd be a good place to stop. I'm gonna excuse the jury for the night, then we can all talk about whatever this objection is or this issue is. And then as soon as they had those arguments and the court made the ruling, the court addressed it as soon as the jury came back. And I think that, especially when you're just kind of looking at the realities of everyday life, I don't think the jury, so I guess defense counsel is kind of trying to have it both ways, saying either that this testimony about the Facebook identification was so damning and so prejudicial that the jury sat there and thought about it all night, and that no curative instruction could have gotten it out of their minds at that point. Or they're saying that the court's curative instruction was too vague and didn't tell the jury what exactly the evidence was that they were supposed to disregard. So either the jury couldn't possibly forget it, or they couldn't possibly remember it enough based on this argument. And so I think that the way, just common sense of the way that our memory works, I think that the court's instruction here was enough to alert the jury to the evidence that the court was referring to without unduly highlighting it or highlighting the prejudicial effect of it, but still communicating the important thing, which was that the jury was to disregard that. And I think this court presumes that the jury followed those instructions, absent evidence to the contrary.
Well, usually, I mean, there's certain types of evidence that's so inflammatory that that presumption doesn't apply. And the question, I suppose, is this one of them?
And, Your Honor, I don't think it is. For the first part, as I argued in my brief, MC never came out and said Mr. Nooner was the person that I saw in the car that day. I think the court was right that MC's testimony got close to that, saying, she said Mr. Nooner's name, which there was no objection to, and then later on, when the prosecutor was trying to clarify, how did you know that name, especially since Mr. Nooner was a stranger, MC said, that's the name that I was told. My father showed me his picture on Facebook. And at that point, defense counsel objected, and MC didn't testify any further. And so I disagree that she came out and identified Mr. Nooner as the person in the car. And I don't think that Mr. Nooner's proposed curative instruction actually would have neutralized this prejudice, because it didn't address the arguably impermissible identification. It instead highlighted other evidence that defense counsel could raise with different witnesses, that there was no photographic lineup conducted in this case. And I think, as the trial court rightly said, when we are faced with potentially prejudicial or inadmissible evidence, we don't ring a later bell and hope that they forget that the first bell was rung. We instead tell them to disregard that bell. And the trial court, who was there, was there all through voir dire, who had observed this jury all through trial, said, I think that this jury is a smart bunch and they will follow my instruction.
Do you agree that if what happened was in fact an identification of the defendant, that its admission was unconstitutional?
I do not, for a couple of reasons. This issue was not briefed, but if there was an identification, there was no state action. It was the victim's father that showed her the Facebook picture. It wasn't police or anybody like that. And so I don't think it rises to the level of a constitutional issue. I think it does raise potential reliability concerns, just from an evidentiary standpoint, so 403. And so I do disagree that if there is error, if this potential identification was problematic, harmless beyond a reasonable doubt standard does not apply. It would be non-constitutional harmless error. And it's looking at whether this substantially influenced the verdict. And I think when you combine the court's curative instruction with the other evidence corroborating that it was in fact Mr. Nooner in the car, the matching license plate by all but one number, which the odds of that are very low, as well as the defendant's confession. And I know that defense counsel, both at trial and on appeal, substantially attacked that confession, but the fact of it is that the jury believed that the defendant confessed, or that the defendant was at least the person in the car. So I do not think that any error here was harmless, or warrants reversal. And then just to briefly touch upon the sufficiency of the evidence issue, I think the dictionary definition of invite to request the presence or participation is the plain and ordinary meaning of when people say, oh, I'm going to invite you over to my house, or I'm going to invite you to dinner. They are asking you to join them for dinner in those activities. And I think...
Let me explore that if I can.
Sure.
Obviously, this is a hypothetical, but suppose a person is driving around town, he's got a convertible, and he says the same thing that this defendant said repeatedly, and on a couple of the blocks there were children around, and he's prosecuted for enticement of a child. Would that be sufficient evidence to support a conviction?
I think taking your hypothetical, I'm assuming in your hypothetical he's not directing these comments at any particular children, they just happen to be around
Well,
when he's driving.
he just likes these words, and he keeps saying them. He's driving around and he keeps saying these words. So I suppose it's up to the listener to figure out whether or not he's directing it towards any particular people or children.
I think that in that situation, it is very close, and I think in that situation, a jury might well acquit. But I do
Well,
think...
that's not the question. We're not asking about whether a jury would convict or acquit. We're asking the legal question, would there be sufficient evidence to support a conviction?
I think in that situation, without more circumstances, that might not be sufficient evidence for enticement of a child.
So
But
why is this case different?
this case is different for a couple different reasons. For the first off, we have when Mr. Nooner when the girls first see Mr. Nooner, he's in his car, making masturbation movements with his hand and actually backing his car up alongside the girls. And when they ignore him and pretend to go up to a different house, he drives away. He circles back around the block towards them again, slows down, and then propositions them for oral sex. And it's only when, by Mr. Nooner's own words in his confession, it's only when the girls ignored him that he decided to drive away. And so I think all those circumstances, asking from the front seat of a car for oral sex from child, I think that is sufficient to constitute an invitation. And I think all the remainder of the circumstances support an intent to commit sexual assault on a child. So intent is always proven by circumstantial evidence, and I think that a reasonable jury here could conclude beyond a reasonable doubt that Mr. Nooner had that intent. I think Mr. Nooner made a lot of hay about the fact that the car never stopped, so it technically wasn't possible for the girls to get in the car. I think it misconstrues the relevant inquiry because the statute doesn't require it to be possible for a sexual assault to occur. If that were the case, then cases like Douglas couldn't stand, which was an undercover operation where there was no underage girl. The defendant only thought there was. And so I think that the question of whether or not it was physically possible for the girls to get in the car is immaterial when it comes to enticement of a child. The actus reus is the invitation or persuasion. The mental state is intent to commit sexual assault on a child. And I think that with the evidence presented here, there was sufficient evidence, viewing all of the evidence in the light most favorable to the people and every reasonable inference in the people's favor. And I think that we have met that threshold here.
Can I take you back to the standard of review?
Sure.
And the identification?
Sure.
You say it's not a constitutional harmless error test because there was no state action.
Correct,
Because the father showed her the Facebook picture.
correct.
But it was the prosecution, wasn't it the prosecution that elicited the in-court identification?
I think that when you read it in context of MC's entire testimony, and this is my reading, and I know it's, subject to reasonable differences, but my reading of the question was the prosecutor did not intend for her to say, and when you say he drove around a second time the next day, I don't think the prosecution intended for her to say Justin Nooner. I think he expected her to say the same person I saw the day before, but MC is an 11-year-old girl. She was very nervous. Her testimony, she had some trouble following the questions. So I guess to that extent, yes, the prosecution asked the question of who it was the next day, but I think what the defendant objected to was the Facebook identification from the father, and when the prosecution started going down that line of questioning.
Yes, but that
Yes.
wasn't that, I don't know, incited or enticed maybe by the prosecutor asking, how do you know that's him? Who told you that name? By asking those questions, didn't he invite her to say, oh, I made an identification on Facebook thanks to my father's research?
I think
Paraphrasing what she said.
I think that is where the prosecution was going. I don't think that he ended up getting all the way there because of the defense counsel's objection of saying, and was that person that you saw on Facebook the person that you saw in the car? And is that person you saw in the car the person sitting in the courtroom today? I think when we have an in-court identification, normally what we're talking about is, and do you see the person who
Yes.
committed the crime here today? And they say, yes, it was the defendant, he's sitting at defense counsel's table. So in that case, that would be state action eliciting an in-court identification. I think this case, it's a little bit murkier because we have the pretrial identification from the father and then the prosecution.
And the
bringing it up.
prosecution is charged with knowledge of that, aren't they? I mean, they knew, they said that they were not going to introduce this evidence, and then they either inadvertently or maybe, through a roundabout way, got it in anyway.
I think the record, at least the way that I read the record, this was a different prosecutor than from the first trial when the first ruling was made. I think it was a mistake and then the prosecution was just trying to do their best to correct it, or at least, I guess, give the jury a little bit of context of why did this girl know this complete stranger's name, and just try to make that a little bit more clear for them. But I think at the end of the day, whether or not it was proper or not, to go down that road, the trial court decided it's potentially prejudicial. I'm going to sustain the objection, and I'm going to give a curative instruction and tell the jury to disregard. And I think that
But he never told
that
the-
was a reasonable choice for
But
the
he
trial
never
court to
told the
make.
jury to disregard the girl's identification. He said, just disregard all that testimony about pictures. That's what he said, right?
I think he said, and if I may just briefly answer your question, I believe what the court said was you heard some testimony about Facebook and things of that nature. He referred them to the end of the testimony, and I think a reasonable juror would understand that that's the testimony that the court was referring to. The people would respectfully ask this court to affirm.
Thank you. Mr. Hardy, you're going to add 25 seconds to your time.
Thank you.
I guess I'd like to address the state action first. As the Attorney General said, that issue was not briefed, nor was it raised by the district attorney at trial. I would ask this court to consider that argument waived. In any event, if the court was predisposed to consider state action, the state action here occurred when the prosecutor elicited the testimonial identification from MC. And then Finally, I want to be clear that I'm not requesting supplemental briefing here, but if this court were inclined to rule on state action in this case, then I would request an opportunity to file a supplemental brief on that issue. I think if the court were to look at State v. Dixon from the Supreme Court of Connecticut, which is cited in the briefs, that court has determined that introducing an identification for the first time at trial by the prosecution satisfies the state action element. Getting back to your question, Judge Ramon, about, could this error ever be harmless beyond a reasonable doubt? The other thing I would like to highlight is how long the jury took to reach a decision in this case. They went back for deliberations at the end of one trial day, and then they were back there for the entire next day. The only question they asked, and that was at 4:30 at the end of that second day, was, what if one juror has doubt, but not double underline, all capital letters, reasonable doubt? That's issue 5 in the briefs. My contention is that the trial court erred in responding to that question, but I think the content of that jury question is clear, that we had a holdout juror here. And this is a case with 2 charges, and we're talking about 30 seconds of conduct. So this was clearly a very closely contested case. As far as defense counsel is trying to have it both ways, I respectfully disagree with my adversary here. Defense counsel was clear from the very start, after the testimony came out, that what they wanted was an instruction that told the jury that no identification could be considered in this case. In fact, defense counsel teed it up way back in pretrial. There were different lawyers. However, that was law of the case. Defense counsel argued that it was law of the case when the issue arose. It's in the record. The prosecution didn't argue against that. The court accepted that. The court made findings that the water had been dirtied and the bell had been rung in this case. And as far as whether or not the error was constitutional here, well, we have the pretrial motion. I mean, usually what we look to in terms of preservation, defense counsel did everything possible here. They filed the pretrial motion. They alerted the court when the issue came up. And defense counsel constitutionalized this issue even after the testimony at page 55 and 56 of the record, 529-15, arguing that this had impaired Mr. Nooner's rights to a fair trial under the Constitution. Getting to your hypothetical, Judge Berger, on the sufficiency, this case is the Corvette hypothetical. Again, this was a case that took a while to get to trial, and we had 2 child witnesses, only one of which really had a memory of the event. But the way I read the testimony, it was very unclear that there was some backing up or movement of the car before the girls approached it. The girls walked up to the person who was in the car, and that's when the hand motions occurred and the car moved away, came around, and then the remark is uttered without the car stopping. That is not factually distinguishable from the Corvette hypothetical that you mentioned, Judge Berger. Or if there's anything to factually distinguish it, it's much closer than any of the other examples we've talked about to that Corvette hypothetical. I see I have a minute left. But unless the court has further questions, I would ask that the court vacate on the Mr. Nooner's convictions on the sufficiency issue. And if the court does not vacate, then I ask that it reverse and remand for a new trial. Thank you.
Thank you. Thank you for your excellent arguments. The case is submitted. We'll issue a written opinion as soon as we can. You're excused, and as soon as you've vacated the table, we'll set up for
May it please the court?
Yes.
Counsel. My name is Dan Wartell, registration 34902, on behalf of the appellant, Kinnick. This case arises from a 2-week jury trial. It involved complex issues spanning approximately 25 years, and there are myriad issues up on appeal. I'd like to focus on 4 of them today. The first is the court's refusal to instruct the jury on the applicable standard of care. Specifically, the trial court, let me back up. The appellee actually filed a declaratory judgment action as the plaintiff in this case, seeking a declaration by the trial court that it was not a fiduciary. In response to the briefing at summary judgment on that issue, the trial court found the opposite. The trial court found that at all times, the appellee was a fiduciary, and as a fiduciary, the trial court defined the scope of that duty as an obligation to only charge reasonable compensation. At trial, there was evidence adduced, and during instruction argument, the appellant offered or tendered a jury instruction that would have tracked verbatim the trial court's decision on what the scope of that duty was. The trial court refused to instruct the jury on that issue, and as a result, the jury was left with nothing more than the contract in order to determine what compensation, if any, was owed.
Which contract?
Well, there was 2 contracts, Your Honor. There was
2 written contracts.
2 written
Were
contracts.
any damages awarded under those 2 written contracts?
Thank you, Your Honor. The answer to the first contract is 0.
Right.
And the answer to the second contract is yes.
I thought that the jury awarded damages for this in connection with the sale of 4 different sets of property. Well, not sale, 3 sold and 1 maybe sold.
Yes.
So those were based on oral contracts, weren't they?
They were, Your Honor, and that's one.
So how do you decide, how can you argue that there's a fiduciary, that a ruling on fiduciary duty, which is really based on the written contract, even applied to those contracts?
Well, an economic loss rule argument was presented to the trial court and rejected by the trial court, and the trial court determined that in addition to whatever contractual obligations the parties had agreed to, pursuant to either an oral or a written contract, that on top of that, there was an overlay, given the trust and the confidential relationship that the parties had shared, that it must also be viewed through the lens of reasonable compensation. And that is what we claim was error, that the trial court gave the jury no lens through which to view whether or not the compensation that it was seeking was quote-unquote reasonable, and instead was left only to determine whether or not the contracts provided for compensation. Yes, Your Honor.
The contracts provide, each of those oral contracts, I assume, I didn't read all the testimony, provided for some kind of compensation based on a differential between the purchase price and the sale price of the buildings times the percentage.
That is what the alleged oral contract at issue was, yes.
The way that Newcastle claimed those 4 or 5, whatever number of sales, was a number much larger than the verdict the jury came up with, was it not?
I believe so, yes.
So what, if the jury didn't award what they were asking for, can't we presume that they gave what they thought was a reasonable amount of fees as opposed to the contractual amount of fees?
Well, we just don't know, Your Honor, and that's exactly the problem that the Miller v. Byrne case addressed when a Colorado Court of Appeals opinion that specifically said in the context of bad faith, without a definition of that concept, we cannot determine to what extent the jury applied its own definition or was misled. And our position is that without the jury being informed that they could only apply reasonable, we don't know what the basis was for what would be characterized as a compromised verdict, Your Honor.
But don't you lose, if we don't know, don't you lose? You're the one who's claiming error.
Correct.
You acknowledge that the jury was correctly instructed with the pattern fiduciary duty instruction, right?
Correct.
So the only thing you didn't get is a specific instruction by the court that included in the general breach of fiduciary duty or fiduciary duty is the duty only to charge reasonable fees. But the judge said you were free to argue that to the jury, and you did.
Correct.
And don't we, as an appellate court, have to assume that the jury, number one, followed the court's instruction and considered, to the extent they thought it was applicable, your argument?
Your Honor, if the jury was given the proper guides through jury instructions, then absolutely we would be obligated to defer to and presume, as you suggested, that they followed the instruction. Our point here is that the jury was essentially left without any guidepost as to determine what was reasonable compensation under the circumstances. And without an instruction telling the jury that that's a specific issue that they need to consider, it left the jury in the dark and unable to make that
Well,
determination.
didn't you present expert testimony that the fees were unreasonable?
Some expert testimony was, Your Honor, yes.
So when you say the jury had no guidepost to determine whether it was reasonable or unreasonable, you gave them a guidepost.
As a factual matter, yes, but as a legal matter, no. I'd like to run to the next issue, which involves what are called the Rio properties. And this is an issue that involves a claim for anticipatory repudiation by Newcastle, essentially claiming that because my client had given indication that it would not honor the agreement, that led to a justiciable controversy, and we disagree. We've cited case law in our briefs that the only obligations or performance that was due was the sale of these properties. It was a unilateral contract where the only time any fee would be owed is if and when these properties sold.
Did you make this argument for the first time in your reply brief?
I believe we raised it in our opening brief,
The unilateral contract theory?
the unilateral contract theory was an issue that we raised in response to case law from the answer brief that addressed the proposition or the case law cited by the appellee that anticipatory repudiation presents a justiciable controversy. And in response to that, in our reply brief, we provided case law that stands for the proposition that once the contract is unilateral in the sense that only one side owes obligations under it, that anticipatory repudiation is no longer an effective tool to make a justiciable controversy out of one that is not yet ripe.
Well, how do you get around the problem that you either stipulated to or agreed to the anticipatory repudiation instruction? Presumably you knew, everyone knew, that there hadn't been a sale of the property. So if there hadn't been a sale of the property, on your theory, the jury shouldn't have been instructed at all on anticipatory repudiation.
Your point is well taken, but it would not serve to overcome the fact that the plaintiff has the obligation in that situation to prove their case, and they have the burden of production, the burden of proof, and the burden of persuasion. And here, regardless of what the jury instruction may or may have said, as a matter of fact, the performance under this particular contract was not yet due, and as a corollary to that, it left the jury with nothing but speculation. Because these properties had not sold, performance was not due, and all the jury could rely upon was appraised values rather than what the actual sale value is.
But counsel, let me
Yes,
ask you
Your Honor.
this. Isn't that the nature of an anticipatory repudiation, is that it's not due, but that one side says, we're not going to live up to it, or we're not going to honor it when it becomes due? Isn't that the definition of an anticipatory?
Yes, but the distinction, Your Honor, is that in the concept of a unilateral contract, an anticipatory repudiation, where one side gives clear and unequivocal intent not to perform, that excuses the other party from continuing to perform their obligations under the contract, and at that point they can sue for breach. But here, where you have one condition precedent, which is the sale of a property, which then triggers performance, if that condition precedent has not occurred, therefore performance is not due, it doesn't matter whether or not the party has or has not said they will comply with their contractual obligation, because it hasn't even been triggered yet.
What is the rule in Colorado? What do you have to do in order to preserve in a civil case a sufficiency of the evidence argument on appeal?
If it's a sufficiency of the evidence argument, you need to raise it either through a motion for directed verdict or a J&OV motion.
But you're saying this is not a a sufficiency argument.
Correct. This is a question of law, as with the next issue that I'd like to talk about, the issue of the operation of the 2015 agreement and the integration clause contained therein. And unless I haven't answered your question, I would like to move to
I
that.
have one other question.
Yes, Your
Before you get to
Please.
that I need to ask you. No damages were awarded for the alleged breach of the 1996 agreement.
Yes.
So why is this court, as opposed to the division that will hear the attorney's fees appeal, why should we address that at all?
Because it extends not just to a prevailing party analysis and whether one party prevailed or did not, but also to the essence of this particular claim. So it does have to do with the prevailing party analysis, which is on appeal, as the court noted, in a separate one. But it also has to do with the fact that there was a 2015 agreement that alleged to supersede and integrate the 1996 agreement. And had the court given effect, as we suggest that it should have, to that 2015 integration clause, then as a matter of fact and law, a 1996 agreement, which has been superseded, is no longer a viable contract that forms the basis for a claim for relief. In other words, the allegations of the 1996 agreement were superseded by the later agreement.
But wasn't there a, go ahead.
Yes,
Go
sir.
ahead, go ahead.
That's a different issue, though.
I'm
The
sorry?
issue on attorney's fees is who was the prevailing party and what did they prevail under the contract?
Correct.
You're saying we're supposed to say that the 2015 contract superseded that, which you're going to get to in a
Yes.
minute, I guess. If we agree with you on that, then it doesn't make a difference.
Correct.
Okay, that's, I think, what Judge Berg.
It
That's
does.
what I understood, Judge Berg.
And we also briefed this issue out of an abundance of caution in both this appeal and the second appeal to make it clear that if the court were to determine that the 2015 agreement superseded the 1996 agreement, that any type of prevailing party analysis that flows from that would be subject to the second appeal.
So, Counsel, you're running out of time, and I'm
Yes.
also interested in that 2015 agreement.
Yes.
Looks to me like there were provisions that conflicted, and I'd like to know your thoughts on 15.31, the ownership and other interests of manager.
Yes.
What does that clause mean to you?
Yes. So what we have with 15.31 is essentially saying that this agreement is not intended to expand, contract, modify, or otherwise any prior agreements. That's the way that relate to a property interest in or sale or fees related to the sale of those agreements. So I believe that that is in there and was intended as a carve-out, but it doesn't resolve the ultimate issue, which is there were no other agreements after the 2015 agreement entered into. One would think that if there were millions of dollars worth of oral agreements, that a party who stands to lose those agreements would have every interest in the world of putting them into the agreement. And if you look at the terms that have been defined by the parties and pointed out to the court, what we have, the key terms are 7.1, which defines what Newcastle's property management fees would be. Then we have, I think, the critical section, which is 7.4, and it talks about from and after the date hereof, if the owner requests in writing that the manager undertake to perform services other than the services provided for in this agreement, then they shall be agreed to pursuant to a separate written agreement. And without such separate written agreement, no compensation shall be due. Our position is that if they had separate pre-existing agreements that would have fallen into the section 1531 that you just cited, that they would have had those in effect. They would have either attached them as a copy to this agreement, they would have created a separate written agreement showing what the intent and the agreement of the parties was, and instead, what we're left with is section 7.4 that says anything outside of here needs to be in writing, nothing's in writing, and therefore what we're left with is this agreement. And this is on par, both factually and from a legal perspective, with the Nelson v. Elway case that we cited to the court. And that Nelson v. Elway case had almost an identical integration merger clause. And what the Supreme Court said is we will not step into a commercial transaction after the fact and attempt to ascertain the intent of the parties when that intent is manifested by an express term in a written contract. And like in the Nelson v. Elway case, what we have here is sophisticated parties represented by their own counsel that are taking an agreement from 1996, superseding it in 2015, and had the parties wished for anything to survive that merger and integration clause, by the terms of this agreement, it should have been in writing, and it was not. I see that I'm out of time.
Thank you.
Thank
Just a
you.
quick question, though.
Yes.
So my understanding is those were oral agreements?
Yes.
All right, so you're saying that they should have then put them into writing
That they,
and had you sign off on them?
correct, because of what 7-4 says, that any agreement outside of this needs to be in writing, and it would have been easy for the parties to take what they later proposed as a multi-million-dollar oral contract and reduced it to writing.
Thank you.
Thank you.
Good afternoon. May it please the court, Andrew Petrie, registration number 11416 for Newcastle.
Mr. Petrie, you have an extra 37 seconds.
Thank you, Your Honor. I'm going to try and proceed through the materials in the same order that Mr. Wartell has addressed them and try and touch upon some of the panel's questions as I go here. So I'm going to start with the applicable standard of care. Judge Berger, as you observed, what the court gave was the stock instruction. And what the stock instruction provides is that the jury is to consider whether the fiduciary, or the person alleged to be a fiduciary, is acting in the best interests of the beneficiary of that relationship. And if you go back and look at the record of this trial, you will find that from the opening instruction, instruction number 1, that the judge gave below, the jury is told this is a case about whether Newcastle has overcharged for its services and whether these folks owe Newcastle for its services. And we spent 2 weeks with fact witnesses and expert witnesses all coming in and talking about here's what we did, here's why the services are reasonable, experts came in and opined, here's how they match to market, here's how they match to other providers with these kinds of services, et cetera. And after 2 weeks of that, to say that the jury didn't understand what was going on and that the issue here was the reasonableness of the fees, I suggest to you is preposterous. And of course, the fees are not reasonable. They're not in the best interests of the beneficiary of the fiduciary relationship. So that's one basis on which to find, even if there were error, that it was harmless. But more importantly, I think you need to put it in the broader context of the case. The Kinnicknick folks brought 5 claims: breach of contract, fiduciary duty, fraud, intentional misrepresentation, negligent misrepresentation. If we just set fiduciary duty aside for a minute, they lost on all the other 4, as well as fiduciary duty. It's difficult to see how one could breach a fiduciary duty if one did not breach a contract, one did not commit fraud, one did not intentionally misrepresent things, or one did not negligently misrepresent things. Because the whole fight over representations and what was made was, what are the services are you providing? Are they reasonable? Are they market? Et cetera. So again, even if that instruction was not as detailed as it should have been, harmless error. The next issue that Mr. Wartell addressed, and Judge Richmond, I should address a comment that you asked about whether these are oral contracts. That's sort of half right and half not, because they started out as oral arrangements, but then they were documented. They were documented in board minutes of Kinnicknick, agreeing to the terms of the contracts. Some of them were even documented in footnotes that the CPAs put together for Kinnicknick's financial statements. There were emails confirming the existence of the contracts. And I'll come back specifically to the Rio agreement because that's one of the items that Mr. Wartell wanted to address. But they certainly started, given the relationship of these parties, as being handshake kind of deals. But they later were then, and I'm not talking a great deal of time, but they were then documented in other evidence that supported the existence of the contract.
So Counsel, if they were later documented, your counterpart says that under 7.4, you had an obligation to put those out there so that everybody was aware of them. Do you disagree with that?
I do, Your Honor, for a couple reasons. I'll start with, we're talking apples and oranges when we talk about the contracts. The 96 contract and the 15 contract are both property management contracts. And both of them have express provisions that say, if you're going to provide other services, in 96, you have to have a separate agreement or a separate understanding. And in 15, going forward then, you have to have a separate written agreement. The fees that were awarded to our client were not property management fees. They were asset management fees, specifically recognized throughout the trial as being a different beast, a different bundle of services, and an entirely different compensation structure.
So the 2015 agreement wouldn't apply to that?
It's absolutely irrelevant, Your Honor. And if you look at the language of the integration clause, 1518, you see that it has two limitations. One is, first of all, the scope. It is limited to the scope of that agreement, which, according to 7.1 and 7.4, to which counsel is pointed, the scope of that agreement is property management services for those particular properties. The second limitation is a temporal one. It says from this day forward. In other words, any new agreement that you might want to have, you need to document in writing. There's nothing in that agreement that goes through and says any agreement you had previously that is outside of the property management services for these particular properties. Any other agreement you might have had is somehow waived, absorbed, integrated, whatever you want to call it. There's no provision to that effect.
And as I recall, there was testimony by your client's representative that he never would have entered into that agreement, the 15 agreement, if what was on the table was releasing all these other obligations.
That's entirely correct. And you'll recall that Ben Kurtz's testimony was that the revenue under that agreement for a partial year, or under all three of the 15 agreements, was about $50,000. And then they weren't about to give up millions of dollars in fees that they'd earned over the years and had not been paid for a swap on $50,000.
Could you explain the Rio agreement and how a fee is determined when, on the sale of a building that's never been sold?
Yes. The Rio
And may
agreement.
never be sold, as far as we can tell?
The Rio agreement covered 3 commercial properties, 3 lofts downtown. And it's actually documented in a proposal that was submitted to the Kinnickinnick folks. There was an email in the record that said, we agree to your proposal. And then shortly after that, there were board minutes that said, the board of Kinnickinnick has agreed with that proposal and will pay you on that. And
Agreed, let me make sure I understand. Not only agreed with the proposal to pay, but agreed to sell? Agreed to sell the building?
no, there was not an agreement that Kinnickinnick said, we promise you we'll sell the properties.
Was there any evidence that Connecticut would sell the property, but then when they realized they'd have to pay this fee, they backed out of an agreement to sell? Any evidence like that?
I don't think there's any evidence like that, Your Honor. What the evidence was that they were liquidating the entire portfolio. Everything they had, they were trying to sell. And one of their big gripes was we weren't selling it for them fast enough. We were saying, calm down, the market's going to, get better yet, you're going to leave money on the table. But turning, Judge Richmond, to your, if that answers your
Of course,
question.
yes.
Turning to your question, Judge Richmond, about what's going on with Rio, the evidence at trial was our expert came in, Josh Harrison, and testified that he had calculated the damages based on the appraisal information that their expert had relied on.
But what was the
And-
agreement? This agreement that you said there was a proposal and it was accepted. What did it say, what was the essence of it? That your clients would be paid, I'm gonna call it a fee or a commission, a fee, when the building was sold, based on the difference between the purchase price of the building and the sale price of the building?
Correct.
Something to that effect, right?
Correct. There are actually 2 agreements.
Okay. But it wasn't
Maybe I-
sold.
Well, there was, first of all, an agreement that we would be the listing broker, which they breached. There was also an agreement that when the properties were sold, we would be paid a fee, a percentage fee. Now we get to the essence of Judge Ramon's question about anticipatory repudiation. They told us in no uncertain terms, we're done with you. You're out of that. Somebody else is going to take care of that. We're going to sell it, and whatever happens to it, you're just out of luck. And that is the essence of an anticipatory repudiation claim.
But isn't there a difference if you have two potential anticipatory repudiation claims, and in the first one, the liability triggering event, here the sale of the building, must occur, either because there was a provision that on or before January 1, 2022, we will sell the building. So in that claim, if Kinnikinnick says in 2015, I am never going to pay you a dime, that is an anticipatory repudiation claim. We know that the liability causing event would occur. The problem with this one is we don't know whether or not the liability causing event ever would occur. And the question is that an appropriate anticipatory repudiation claim?
And I'd say yes, Your Honor. And the reasons why are, there's a couple. The first is that if you look at the law of anticipatory repudiation, not every anticipatory repudiation claim waits for that triggering event to happen. And I'll start with one of the big bullseyes that we put in our brief, and that's the United States Supreme Court's opinion. In having a moment on the case, it's Judge Ginsburg's opinion that's referenced in a block quotation in our brief. And in that particular opinion, it was someone suing the government because Congress had changed the rules on a government lending program. And instead of allowing you to sell out your notes and sell your property, the government had said, no, we're just going to continue to impose these restrictions on what you can do with the housing. And in that particular case, none of the transactions had taken place. So to use your phrase, Judge Berger, the triggering events had not happened.
No, but that's, the point I'm trying to make is that the triggering event, even though it hadn't happened, because of the terms of the contract or the law of physics or whatever it may be, it was guaranteed that the triggering event would ultimately happen. That's the distinction I'm trying to draw.
And I think if you look at Judge Ginsburg's opinion, you'll see there is no guarantee that the triggering event would happen. It's in the Franconia Associates case. Forgive me, I spaced out the name. But in Franconia Associates, the question was whether these people could, at some future date, repurpose the properties and not be pushed out of the government program. There was no commitment that was ever going to happen. They just wanted the flexibility to do that. That case is important also for this new theory of the unilateral contract. And I'll start out by pointing, first of all, there's zero Colorado law in support of that.
Don't spend a lot of time on that, because we don't address arguments made for the first time in a reply brief, so I wouldn't spend an awful lot of time on that.
Okay. Then let me move on and just touch briefly, because the panel asked, on the question of the 96 agreement and the 15 agreements and where it fits in with the fees, et cetera, understanding that there is a separate fee appeal.
Before you go there, can you address, it's the same question I asked your opponent, on the Rio transaction, what significance, if any, does the fact that there was a stipulated instruction that was given to the jury on anticipatory repudiation have?
I think that waives the claim entirely. They've tried to get around that by casting it as being a ripeness issue. And the reason why it's not a ripeness issue is because they cite to a bunch of declaratory judgment cases and insurance coverage cases that aren't really informative. They did, however, cite to Judge Taubman's dissent in a case, and even though they cited it for a proposition that it doesn't contain, what it does say is helpful, because he cites to 250 of the Restatement Second of Contracts, which is essentially the same or very similar to the pattern definition of what a repudiation is. And what is required for repudiation is something concrete. It's not enough that you say, gee, I'm really not inclined to perform on the contract. It requires a more definitive statement, a very affirmative rejection to take place. That's what happened here. The jury was given the standard instruction, it's jury instruction number 33, Once they were placed or given that fact issue, was there in fact a concrete rejection? That takes ripeness off the table. It's no longer an issue of subject matter jurisdiction. It is simply a question of what was presented to the jury, what did they decide, and if you don't object to the instructions, and don't, for example, suggest the addition of this new unilateral term into the existing instruction, that's gone. You've waived it. I see I have about a minute left. I just did want to address briefly the fee question since the panel asked about it, and I'll just say this. The 96 agreement, even though there were no damages, and one could posit what was going on in the jury's head, it could just be that they read the 15 agreement and said, you're right, that's property management. You agreed to, any property management had to be addressed in the 15 agreement, so you're done with that. But it's nonetheless a breach. That's one aspect of looking at prevailing party. But more importantly, they had a breach of contract claim. They alleged we breached the contracts, every single one, and committed fraud and misrepresented, et cetera, et cetera. And we prevailed on all of those. I don't think there's any way you can look at the verdict and say we were not the prevailing party under any one of the theories.
But shouldn't the other division decide that?
I think that will be before the other decision, Your Honor.
Thank you.
Thank you.
Thank you, counsel, for your excellent arguments. The case is submitted. We'll issue a written opinion as soon as we can. You're excused in this case. You're okay? Dave?
5 minutes.
We won't take a recess, and we'll proceed to the 2:30 docket as soon as the table is vacated. Some of my introductory remarks again, because people come in and out of the courtroom. I don't think either of these two later cases involve the redaction of names of people. They're not those types of cases, but be aware that we are recording these arguments. They're live streamed. So don't say something you don't want to live in perpetuity, because there's no way to get rid of it once you say it. If anyone in the courtroom has an electronic device that rings or beeps or makes noise, please turn it off so that it doesn't interrupt the arguments or affect our recording equipment. Each side has 15 minutes. Appellant can reserve whatever portion of that time you wish, but you need to manage your own time. It's up to you. Are counsel familiar with our oral argument protocols? Do you have any questions before we proceed with argument?
No, sir.
Okay, let's proceed then with argument in Stewart versus Wu.
Good afternoon, Your Honors. I'm Anthony Viorst. I'm here on behalf of the plaintiff appellant, Mr. Lynn Stewart. In November of 2016, Mr. Stewart, through counsel, served a writ of garnishment on ANPAC Insurance Company, claiming an interest in the tortfeasor Shen Wu's bad faith claim against ANPAC. This was after Mr. Stewart had obtained a judgment in excess of $2.5 million against Mr. Wu. In December of 2016, ANPAC filed an answer stating we only owe our $100,000 policy limits. Mr. Stewart, through counsel, then filed what's called a traverse under Colorado Rule of Civil Procedure 1038, which alleged that ANPAC acted in bad faith toward Mr. Wu. Specifically, and alleged specific actions of bad faith. In addition, the Traverse also alleged that that counsel for Mr. Wu had acted in bad faith by failing to advise Mr. Wu timely of the proposed Basher agreement or non-agreement, failing to advise Mr. Wu timely of the benefits of said agreement, failing to assist Mr. Wu in finding independent counsel to execute the agreement, and failing to allow Mr. Wu to enter into the agreement without independent counsel. So the Traverse requested an evidentiary hearing under Rule 103(8)B, which mandates a hearing at which the statements in the Traverse shall be admitted or denied. And in addition to the writ of garnishment against ANPAC, Mr. Stewart also filed collection proceedings under Rule 69 against Mr. Wu personally, seeking to collect the balance of the judgment. A hearing was held on October 5th of 2017. At that hearing, the court heard argument, but did not, I don't believe the court heard evidence in that matter. The transcript was not available for the parties, but took the matter under advisement, and thereafter ordered that the bad faith claims could not be garnished, and also ordered that the Rule 69 proceedings had to be, notice of those proceedings had to be personally served on the tortfeasor, Mr. Wu, and that because they were only served on counsel and not Mr. Wu personally, they could not go forward.
How many different writs of garnishment actually were issued and attempted to be served?
I think there were multiple. I think there were at least 3 because there were some procedural issues with the writ of garnishment.
One of them that I saw was a writ of garnishment in aid of a writ of attachment,
Right?
but there never was, so far as I could tell, a writ of attachment issued by the court.
I think we would agree with the court that there was no writ of attachment ever issued.
So is that not part of this appeal?
Well, the writ of garnishment would be, I mean, I guess here's what I would say about that, Your Honor. There were procedural problems with the writs that were issued by plaintiff's counsel. I mean, the court even said in one of her orders, plaintiff's counsel is not like a professional collection attorney, which he wasn't. It is sort of a separate skill, and I would suggest that if there are procedural problems, if there were procedural problems with the writ, that the court should remand this matter for perfection of the writ. If the court finds a substantive matter that the writs were improper, then the court should simply affirm.
Well, how could you ever have a writ of garnishment directed to the judgment debtor? I always thought that a writ of garnishment, the whole purpose of it and the sole purpose of it was to reach assets in the hands of a third party that either holds property of the judgment debtor or is indebted to the judgment debtor.
And I think that's correct, Your Honor. That's certainly one of their arguments. And the bottom line is that plaintiff's counsel was trying to find some means to attach or garnish or levy the bad faith claim to which the tortfeasor was entitled. And again, it may not have been done procedurally correct, in a procedurally correct manner, but at the end of the day, I mean, if this court finds that we are entitled to do that, then I think we should be allowed to go back and do it properly. I would agree that you probably, you cannot garnish the judgment debtor because the garnishment is directed toward a third party. I agree with that generally. I think what happened was the plaintiff's counsel was sort of trying to cover all his bases by garnishing both the judgment debtor and the insurance company so that there would be sort of no way out, of that vice. And perhaps he shouldn't have garnished the judgment debtor. I think he also filed separate sort of collection proceedings against the judgment debtor, separate and apart from the garnishment. But in any event, again, we would ask that the procedural issues be dealt with another day and that this court rule on the substance of the matters addressed on appeal. The first matter addressed on appeal is when a judgment creditor obtains a verdict in excess of the tortfeasor's liability insurance limits, can the judgment creditor levy and or garnish a bad faith claim either through the judgment debtor himself or the potential debtor, or the potential debtor to the judgment debtor, and pursue the judgment debtor's insurance carrier directly. So basically, yeah, the question is, can we garnish either from the debtor himself or from his insurance company this bad faith claim? That's essentially the issue. In support of an affirmative answer, we would note that Rule 103-2A authorizes a judgment creditor to garnish choses in action. And as we cited in our brief, a chose in action is a right to receive or recover a debt, which is, quote, not reduced into possession but recoverable by a suit at law. And we suggest that's what this bad faith claim is.
But what's the debt?
The debt is the bad faith debt owed by the insurance company to the insured.
But it's not owed yet.
That's why it's a chose in action, because it says it's not reduced to possession. I mean, I understand Your Honor, Judge Richmond, you're saying it's sort of a contingent debt, and therefore it doesn't qualify as a chose in
Well,
action.
can you point us to any case where a garnishment proceeding was used to litigate the bad faith of an insurance company?
Your Honor, I can't. And, and I know the court issued some supplemental questions about that. And so, and I reviewed those, and I'd have to say the answer is no. And I would also acknowledge that the Steen case probably suggests otherwise. That's a Supreme Court case. I would simply say that Rule 103-2A, which was not addressed in the Steen case, would seem to indicate that you could garnish a bad faith claim. And we would ask this court to at least analyze this matter under Rule of Civil Procedure 103-2A. And, as further support for that, I would note that the rule specifically says choses in action, quote, whether they are due at the time of service of the writ or are to become due thereafter. So again,
Did 103 exist at the time the Steen case was
well,
decided?
I don't believe it did. I mean, I was thinking about that, and the Steen case is from the 60s, and to be honest, I didn't go back and do the math as far as when Rule 103 came into existence, but what I can say for sure is they didn't address it in the opinion. So whether, maybe it just wasn't raised.
So they didn't address it. Do we have the authority to pick a rule of civil procedure over a binding Supreme Court case that appears to be, at least factually, similar to this case?
Well, I mean, the rules are issued by the Supreme Court as well, and so I'd say they're equal authority, and if the rule trumps the case, I would say, yeah, I think a rule, if it's on all fours and applies explicitly, can trump a case, because I think rules and statutes trump cases. I do. All right, so did that answer your question? And I would also note, Your Honor, as I set forth in the reply brief, and I've heard Judge Berger say several times he doesn't like new arguments in the reply brief, but.
I like them, we just don't consider them.
All right, be that as it may. I did mention in the reply brief that the court also would have a supervisory authority over this matter under the circumstances of this case. But I guess the short answer to your question is that Steen would appear to be the only case that addresses this issue. We believe that the rule does authorize garnishment of the bad faith claim and that the rule would trump the case. All right, the second issue is, can trial counsel refuse to accept service for purpose of a Rule 69 or a Rule 103 proceeding? And as set forth in the opening brief, Mr. Wu's counsel represented him throughout the trial, and after the trial did write a letter to plaintiff's counsel stating that, quote, he continues to represent Mr. Wu, so please make sure to direct all communication to my office. And thereafter, he returned to China. Mr. Wu returned to China, his native country, so he could not be served, and so counsel was served in lieu of Mr. Wu. So the question is whether that was legitimate or valid service. We maintain that it was, and I know that was another question issued by this court in advance of the oral argument. First of all, it would be our position that CRS 1355-102, which is one of the authorities cited regarding this matter, we don't believe that applies because it only concerns orders of garnishment that are issued after the application for garnishment is issued. But in any event, that statute does authorize service by publication. So again, if court finds that we're procedurally, there were mistakes made procedurally, that we would ask to go back and serve by publication under that statute. But I think the real issue is whether Rule 4 authorizes service on the attorney. And Rule 4 does authorize by its express terms appointment service on any person authorized by appointment or by law to receive service of process. And so that's the authority we would cite, and the case we would cite in support, a couple cases. One is the Zeff case, 194 P. 3rd, 167, which explicitly states that the client-lawyer relationship is one of principal and agent. So clearly, the lawyer is an agent of the, is an agent of the client, of the principal. But secondly, we would also cite another case, and I know, and this is in response to the court's questions, it wasn't in the brief, but in response to the court question, I've done some additional research, and there is a case called Sutherland versus Automotive Electronics Corporation, and it's 773 P. 3rd, 599, and it states, for purposes of Rule 4E1, the appointment of the agent need not be explicit. The authority to accept service on behalf of the client may be implied from the nature of the relationship between the attorney and the client, including the purpose and nature of the attorney's retainer. Thus, where the attorney is engaged to commence litigation to accomplish a specific purpose, the authority to accept service of process in a closely related judicial proceeding may be a necessary incident of the attorney's express authority. So under the authority of that case, we would ask this court to find service on the attorney was proper, and that therefore commencement of the collection proceedings was appropriate through the attorney, and the service of process is not an issue.
So are we talking about the writ that was directed to the insurance company? Are we talking about the writ that was, I think you concede, improperly directed to Mr. Wu, or both?
The writ directed to the insurance company, I think, was properly served on the insurance company.
Right.
So there was a writ directed to the client, to Mr. Wu. I think there was also a separate Rule 69 collection action started against him. But I would agree, to the extent we're only talking about the writ of garnishment, I would agree that a writ of garnishment should not have been issued against the client.
So what
Against-
difference does it make
against the
whether
judgment.
there was service or not
Okay.
service in that
If that's all we're
writ?
talking about, then I would agree with you. Yeah. All right, I'll reserve the rest of my time. Thank you, Your Honor.
Can I ask you a question?
Oh, certainly, Your
Before you run away?
Yeah.
As I understand it, a chosen action, see if you agree with this definition, I haven't heard it since law school.
Okay.
Chosen action is a right to bring an action for damages based in tort.
I agree with that
Right to bring an
definition.
action, good. Who had a right to bring an action in this case? Mr. Wu did, didn't he?
Yes, Mr. Wu.
So how does the garnishment of the insurance company garnish a chosen action that belongs to Mr. Wu?
Well, then I guess it goes back to, maybe we should garnish Mr. Wu. I mean, again, this is not a professional collection law firm. I don't, and the question, I think the real question is, can we garnish this item of damage? If we can, I guess the second question would be, who should it be garnished from? I mean, it's got to be garnished from one or the other, right? I mean, the statute says we can garnish it. Rule 103, the rule says we can garnish
Well,
it.
there's no question, you could have taken an assignment of Mr. Wu's claim against the insurance company, but your
Yeah.
client never got one.
That wouldn't be a garnishment, though. That would just be
No,
an
I
assignment.
understand. Okay.
So how do you garnish a chosen action? I mean, how does that happen? All right, thank you.
Thank you.
May it please the court, counsel. My name's John Stevens, registration number 32115, and I represent Shenji Wu.
Are you going to split your time with the other counsel?
Yes, Your Honor, I was going to address that. I am
Okay.
only going to address the second issue on appeal related to service on the attorney. The much larger issue is directed towards American National, the insurance carrier, and counsel for the insurance carrier will address that issue. Related to whether a party can be served through his attorney, the court asked a specific question: what authority, if any, designates an attorney as an agent of his or her client for purposes of service of process? There is none directly. Under Rule 4, if you have personal service, there has to be an explicit provision of authority for the attorney to accept service. The case that was cited by counsel, the Sutherland case, there were some distinguishing characteristics in that case. For example, the first attorney for the party that was ultimately deemed to be served through counsel had agreed to accept service, and then there was a change in counsel. So there were many factors involved in that case to determine whether implied service was proper.
Mr. Stevens?
Yes.
This is interesting, but if you can't garnishee the judgment debtor, what difference does the service issue make?
It doesn't, Your Honor. We're addressing because that was an issue on appeal, and I agree with you completely. It's been admitted that the writs were improper on their face, and the order from the trial court says that that the motion to grant the quashing of those writs was granted in part because service was improper and also the writs themselves were improper. So on that point alone, we don't have an issue because you can't proceed with those writs. And you asked a question earlier, how many writs were there? There were 3 writs attempted to be served on Mr. Wu and then 1 on the insurance carrier. All 3 writs, they were objected to and motions were filed stating the specific basis, yet plaintiff's counsel kept persisting with the same status, requesting that service be effected on counsel. And I just wanted to address the question that the court had raised with counsel prior to this oral argument related to authority. There is authority related to implied authority for service. Those are in bankruptcy cases, but we don't have the facts in this case to determine if there was implied authority, because you have to look at all circumstances involved if the intent of the client meant for the attorney to accept service. And in bankruptcy proceedings, they have a separate rule that is more lenient than Rule 4. For example, you can serve people by registered mail or first-class mail, and under Rule 4, under the federal rules and under the Colorado rules, we don't have that. But ultimately, there is no case law that allows for the attorney to be served simply because he or she is attorney of record and the writs themselves were improper. So with that, unless there are questions, I'm going to yield my time to counsel for the insurer. Thank you.
Thank you.
May it please the court, Jared West, number 39041 for Appley American National Property and Casualty Company. So I'd like to start with answering a couple of the questions that the court had during the plaintiff's argument. And the first question was, did Steen address Rule 103? Or was Rule 103 in place during Steen? And the answer to that is yes. If you look at Steen, it expressly says the instant action is an ancillary garnishment proceeding under Rule 103 RCP Colorado. So Steen did address 103. And as the court knows, not only did it address Rule 103, it is directly on point.
Did the version of Rule 103 that was in effect then use similar language as to what things can be garnished?
The answer to that is, Your Honor, I don't know that as I stand here right now. The full text of Rule 103 isn't placed in Steen, and as I was sitting there, I looked at my copy of Rule 103, and the annotations on the changes did not go back to 1965. I do know this, and haven't read the cases. Essentially, a similar version of Rule 103 has been in place since the 1920s. So let me do this. The court issued some questions before our argument, and one of the court's questions was, what authority, if any, allows a plaintiff to try the issue of an insurance company's liability for bad faith in a garnishment proceeding? The short answer to that question is none. A longer answer to that question is, not only is there no authority that says that you can do this, there's a long line of authority that says you cannot do this. And that authority goes back to the 1930s. There's a case that's cited in the brief called Black versus Plum. It's from 1935. And that case addresses what type of choses in action are garnishable. And that case says that 2 things aren't garnishable: tort claims and unliquidated claims. Building upon Black versus Plum, we next get to Steen versus Aetna. That's 1965. And in Steen versus Aetna, you couldn't get a case that is more on point. I mean, it is almost a mirror of our facts. In Steen versus Aetna, you had a plaintiff that took a case to trial. They got a judgment in excess of the policy limits. And then what they decided to do was file a Rule 103 garnishment proceeding. And in that garnishment proceeding, they attempted to recover the amount in excess of the policy via garnishing a potential bad faith claim that the insured would have. And as we know, the Colorado Supreme Court said, this you cannot do. It explicitly said, if the insured is to be held liable for the tort of bad faith, it must be in a separate tort proceeding, not subject to the garnishment rule. Then we move forward to 1972. There's Northland versus Basher. And the plaintiffs cite this case in their brief for the proposition that it supports a finding that a judgment creditor could use garnishment to litigate bad faith. The problem with that is that Northland versus Basher expressly approves of Steen, and it says Steen is not overruled. So what the insurer in Northland argued was, it's a similar case to Steen. There was an excess judgment, and then after the excess judgment, the judgment creditor began collection proceedings against the insured. And what the insured did was, they said, well, you can't proceed in garnishment because Steen says we can't do that. So we're going to do something else. What we'll do is I will assign to you my right to collect damages from the insurer, but I'll file a lawsuit against the insurer. You pay for my lawyer. So that's what a Basher agreement is. So the insurer defended that, saying, this is essentially an end around Steen. You can't do this. This is an illegal agreement. It's void against the public policy of Colorado. The Colorado Court of Appeals said, no, we're going to allow this. Then when the Colorado Supreme Court got it, they said, I'm going to address the issue of whether or not Steen has been overruled, and we hold it hasn't. Steen is good law. This is something different. This is an assignment where the insured is bringing claims against the insurer because they have standing to do so. So that highlights one of the main problems that's caused some confusion, I think, in plaintiffs' attempts to use the garnishment statute. Throughout, they've confused obtaining title to the claim with then litigating the claim. And it's been, those concepts have been used interchangeably. So, simply, we don't believe garnishment can be used to obtain title to the claim because, for instance, my client, as the insurer, doesn't have title to a claim against itself. If anybody has title to that claim, it's Mr. Wu. And we know you can't use garnishment against the judgment debtor.
Counsel, let me ask you this.
Sure.
I understand your arguments concerning Steen and Basher and Nunn, 103. I have sort of a policy question, if you will. When I read Mr. Stewart's brief, what I got from it is that they were saying the reason we're forced to make all of these attempts at garnishment is because during the process, when we took the non-agreement proposal to council, we got no indication that they'd ever passed that along to their client, which is why we think it was bad faith insurance from a settlement standpoint. From their standpoint, what can they do to make sure that that's not the case, that it is being communicated?
Well, for my issue, Your Honor, is what my client wasn't involved in the proceedings until the garnishment. You know, there was a judgment and they were brought in to garnish. That's really an issue of what happened between defense counsel and their client. And I don't know the answer to that question, but I would say this. Plaintiff does not have a vested interest or have a right to the defendant's bad faith claim. The defendant may choose to enter into a Basher agreement or enter into a Nunn agreement, but they don't have to. That's the defendant's choice.
But they need to know about it if the offer's made, don't they?
I would say that, you know, my understanding of the rules of professional conduct and the rules of are that you have an obligation to convey a settlement offer to your client. But that wasn't an issue that was tried below. That was an issue in the case below. There's no record on that. I mean, that's really an issue, and maybe this is a separate thing. All of those issues were really raised for the first time in the reply brief. They're not raised in the opening brief, and I think those issues probably aren't before the court on this appeal. But more fundamentally, I don't think that is the question. I think the What plaintiff is trying to do is saying that I want this claim and I have a right to get it. And I don't think that's true. I think that if a insured decides to avail themselves of those mechanisms, they can, but they don't have to. And if Mr. Wu decided not to, then that's his choice. Back to the point about some of the confusion in the briefing and some of the confusion as to why multiple garnishments are issued. I think the problem was plaintiff was confusing with attempting to obtain title to the claim with attempting to litigate the claim. And the case law is very clear that you cannot litigate a tort claim via garnishment. The case law goes back 84 years that says that. In the brief, much of plaintiff's argument is based upon their reading of a case called Denver versus Jones. And that's a case that describes what a chosen action is. The problem with Denver versus Jones is that it isn't a case about garnishment under Rule 103. What that case is in that case, it had to do with the meaning of the term things in action that was used in an old fraudulent transfer statute. In that case, you had a fireman, he had a judgment against him, and he decided when the collection efforts came, what he was going to do is assign his wages to a third party, which I didn't know you could do, but apparently that's something people used to do. So he assigned his wages to a third party, and then when the garnishment came in, he said, those are my wages, I assigned them over here.
Let me ask you this, whether it's through garnishment or some other collection device, Mr. Wu has a potential claim for bad faith against your client. That's an asset or contingent asset, whatever you want to call it, of his. Why can't, by some collection mechanism, the judgment creditor levy on or attach that asset?
Well, I think they could try that. In this case, the process they used was Rule 103 to try that. There may be other mechanisms, Rule 102, which is the writ of attachment rule. Rule 69 was the writ of execution rule. Perhaps they could try those. As set forth on our brief, though, I think they're going to run into problems with whether or not a bad faith claim is exempt from levy, attachment, or garnishment as a personal injury claim. There's an exemption for those in Colorado law. And I did cite some case law that says where the Colorado Supreme Court recently addressed whether or not a claim of insurance bad faith was a personal injury. And the court said it's a close call. They didn't have to decide it, but they ultimately said it's a close call because we don't have to decide it, we're not going to. And then it moved on to decide the matters on a different case, or on a different fact. And that case was Guarantee Trust versus the state of Casper. So to answer Judge Berger's question directly, there may be a way they can try and do it, but they didn't do it here. Okay. There was one last thing I wanted to bring up. In preparing for the argument, I did notice there was an error on page 17 of my brief where I said, fact that an excess judgment was entered does mean a bad faith claim against ANPAC is not contingent. It should say does not. I think it's pretty clear through the rest of that paragraph, but I just wanted to bring that to the court's attention. If there's no other questions?
Thank you.
Thank you.
Thank you, counsel, for your arguments. The case is submitted. Oh, did you have 2 minutes left?
1 minute.
30, how much time?
I have 32 seconds.
No, he has 1 minute left.
Right. 32 seconds? I'm sorry.
All right. I'll take my 32 seconds, I'm sorry. So they make a lot of hay about the fact that no agreement was ever entered. It is our position, I appreciate Judge Roman bringing this up in his questioning, that he never had the chance to enter into this agreement. My client is the one who lost his leg in this accident, Your Honors. Please don't forget that. My client is the aggrieved party here. Mr. Wu was never given the opportunity to enter into this agreement because it wasn't properly shown to him, and then when he wanted to enter into it, he wasn't allowed to sign it. And if this judgment stands the way it is, then they can hide the ball that way for time immemorial. Thank you.
Okay, thank you. Now the case is submitted. Counsel, thank you for your arguments. You're excused. We will issue a written decision as soon as we can. Do you want to? You want a break?
I'm still good.
You still good then?
2 minutes.
Okay, we're going to take a very Please be seated. The last case on our docket is Houchin versus Denver Health. So I think everyone was here before, so we can just proceed directly to the argument if everybody's ready.
May it please the court, I am Brent Johnson of Fairfield and Woods on behalf of Denver Health and Hospital Authority. Denver Health submits that the three claims asserted by Mr. Houchin under the recently amended Colorado Anti-Discrimination Act, or CADA, are tort claims or claims that could lie in tort, and they are therefore subject to and barred by the Colorado Governmental Immunity Act, or CGIA. Denver Health asks this court to reverse the decision below and remand with directions to dismiss Mr. Houchin's CADA claims. Three decisions from this court and the Colorado Supreme Court over the span of 30 years present a very consistent approach to determining whether statutory claims are subject to the CGIA. The first of those three decisions was by the Colorado Supreme Court in State Personnel Board versus Lloyd in 1988. That involved a state employee who brought a claim under the State Employee Protection Act, or SEPA, a whistleblower claim. He was seeking damages for harm to his reputation, to his ability to make a living, and for pain and suffering. The Colorado Supreme Court looked at the damages that he was seeking and ruled that this was a tort claim, that those damages fall within the CGIA, and therefore his claim was subject to the CGIA. It also held that the public purpose behind SEPA to allow state employees to come forward and blow the whistle on improper state action did not negate the applicability of the CGIA to SEPA. Those holdings apply equally to Mr. Houchin's CADA claims in this case. The second decision was the Supreme Court's decision in City of Colorado Springs versus Connors in 2000. There, the court ruled that claims under CADA as it existed at that time were not subject to the CGIA. But under the 2013 amendments to CADA, which I've referred to in the brief as the 2013 Act, they were effective 2015, the Supreme Court's analysis in Connors makes clear that the claims now asserted by Mr. Houchin with the newly added tort remedies do in fact constitute tort claims that are subject to the CGIA.
Are you saying that the claims asserted by Mr. Houchin are subject to CGIA, or any claims now brought under the current version of CADA are subject to the CGIA?
Your Honor, as we've mentioned in our brief, there's a kind of open question which we believe this court need not decide, and that is whether the Colorado Civil Rights Commission retains its separate authority under CADA to consider a claim, to actually hold an evidentiary hearing, and to grant equitable relief. And the 2013 Act clearly limited what relief the CCRC could grant to equitable relief. That issue is not before us, but I see no reason why the Colorado Supreme Court's decision in Connors would not continue to be valid with respect to the CCRC's authority in that respect. And in fact, Section 108 of the CGIA refers to an action that lies in tort or could lie in tort as barred, and if the defense is asserted, the court shall stay any discovery. I have not seen any case in which a regulatory body of the state is barred from exercising its regulatory authorities by the CGIA.
But suppose Mr. Houchin's complaint were strictly limited to the pre-2013 remedies. In other words, he says, I am only seeking the remedies that the Supreme Court said were not tort claims in Connors. Is that claim subject to the CGIA today?
Yes, Your Honor, and I'll give you several reasons why. Number one, the CGIA itself states that it bars all claims which lie in tort or could lie in tort, regardless of whether that may be the type of action or form of relief chosen by the claimant. The Supreme Court in a decision in Robinson versus Colorado State Lottery in 2008 said, the CGIA is less concerned with what the plaintiff is arguing and more concerned with what the plaintiff could argue. Number three, if those claims that Mr. Houchin could assert for the individual tort remedies under CADA, if those claims do lie in tort and are subject to the CGIA, under the CGIA, courts have no jurisdiction to hear those claims. I submit that an individual plaintiff cannot somehow magically convey subject matter jurisdiction on a court by limiting the remedies that he is seeking in that individual case. So it is my position, Denver Health's position, that anytime an individual goes into court under a claim on CADA against a governmental entity other than the state, that claim is subject to and barred by the CGIA.
What if there's another purpose behind the CADA, and it's a primary purpose, and a primary purpose is to eradicate discrimination? Wouldn't that be a different grounds for
No, Your Honor.
affirming what the Supreme Court had done, even though it was on a different basis?
No, Your Honor, I don't believe so. And the Supreme Court actually ruled directly against that argument in the Lloyd case, rejected the plaintiff's argument that the public policy in SEPA should mean that this is not subject to the CGIA. There was discussion in Connors about the public purpose in CADA, but if you read that decision very carefully, the court backed into that by first analyzing the relief that was available under CADA. The court looked at the fact that there were no damages, compensatory damages available, et cetera, and only equitable relief. And it was because of that, if you read the decision, it says that it was because of that that the court ruled that the primary purpose of CADA as it existed then was to fulfill the societal interest in eliminating discrimination.
But under your reading, much of the Supreme Court's analysis in Connors was really unnecessary, was dictum, because under your reading, as I understand it, you analyze whether or not the claim lies in tort or could lie in tort. If there are legal remedies, it lies in tort, end of story, CGIA is applicable, and yet there's pages of Supreme Court language that seems to go beyond that and says, well, yes, that's true, but in addition, these are special functions, basic core functions of the government to eradicate discrimination, and those aren't traditional tort claims.
Your Honor, I think what really is happening in Connors, and there's language in several cases that says that the type of damages available alone is not determinative, but I think it's not a two-way street. I have not seen one single CGI case, and I have read a lot of them, where compensatory tort damages were available, and the court said that was not subject to CGIA. Now, by contrast, when the court looks at a claim and only equitable remedies are available, that is not the end of the inquiry. And the court in Connors noted that and said, look at some claims like defamation or nuisance. There may only be equitable remedies available. Judge Berger, your decision in the Lyons case talked about whether the claims were equitable. And where there's only equitable claims, that doesn't, am I getting this backwards? Where there's only equitable claims, the court still looks to see and goes further. And it did that in Connors. It went further than that in Connors because there were only equitable claims available. But I have never seen a case where legal tort damages were available and the court goes further or finds that it's not subject to the CGIA. And in fact, in Connors, the holding in Connors was very limited. And I want to stress that we're not asking this court to overrule Connors. We are asking this court to recognize the limited holding. The court expressly stated, we hold that claims for non-compensatory equitable relief based on violations of civil rights statutes such as a CRA are not claims for injuries which lie in tort or could lie in tort under the CGIA. After that, so that's limited, that holding does not apply to the claims that Mr. Houchin is bringing here. Our argument is outside of that holding in Connors. After that, the Supreme Court expressly recognized that the result would be different if tort remedies were available, stating, quote, Conversely, a claimant who seeks compensatory relief for personal injuries suffered as a consequence of prohibited conduct has brought a claim which lies or could lie in tort for purposes of the CGIA.
And what if the claimant seeks both compensatory and equitable relief, both back pay as she sought in Connors, and compensatory relief? Are
That
some
would-
of the claims subject to CJIA and some of them not?
That claim would be a tort claim that is barred by the CGIA.
But they said, as you just read, if you seek to redress discriminatory conduct and the relief does not compensate the plaintiff for any personal injuries, the court should conclude the claims are not for injuries which lie in tort, and they're not within the meaning of CGIA. The sentence before, what you just read, says that very thing. That's what they said.
That's where a claim does not allow those kinds of compensatory tort remedies, Your Honor. Claims for non-compensatory equitable relief,
But in Connors, she was seeking back pay and equitable relief.
back pay is considered an equitable remedy.
Okay, so and if a person brings a case now seeking, if you want to call it equitable remedy, that's fine, back pay and equitable relief, injunctive, reinstatement, and some other compensatory damages, what side of the line, do we have to decide what side of the line that falls on for purpose of CGIA?
No, Your Honor, the claim, if that individual goes into court, CADA authorizes the recovery of compensatory damages for emotional distress. It authorizes punitive damages. And that claim is a claim that lies in tort or could lie in tort, and so therefore it's barred. It doesn't matter that they're also seeking equitable remedies.
Can I change this direction just a little bit? I want to talk about Section 8G.
I'm sorry, 8?
8G of CADA.
Okay, go ahead.
No, the CGIA.
That's part of Section 405?
Yeah.
Yes.
Okay, go ahead.
Yes. So you say that that is a waiver provision. But isn't it an exemption provision? In other words, isn't it a provision that says whatever the word state means, this is an exemption from the application of the CGIA? I looked at many, many actual waiver provisions of the CGIA, and none of them use language like that. They all start with the following claims or injuries are waived. There's no such language like that in 8G.
Your Honor, when it says, I think the language of that section that you're talking about says claims for compensatory relief against the state are not subject to the CGIA. I think that the legislature is saying we're wanting to make very clear that these claims can be brought regardless of the CGIA's applicability. I don't know if it matters whether one calls that a waiver or an
It does,
exemption.
it matters a lot, because if it's just waived, you still have to comply with the notice provisions. If it's not applicable at all, you don't. So it could matter a lot. So you think that's an exemption provision, not a waiver provision?
No, Your Honor, I've always considered it a waiver provision. I think that the legislature is saying that although this claim against the state might be barred by the CGIA, we are telling you that we're not going to bar it. I think it's waiving the immunity that would otherwise exist. I would like to reserve my remaining time for rebuttal.
Can I ask you one question? I'm
is-
sorry, Mr. Johnson.
I'll give you a little extra time so it doesn't use up all of your rebuttal.
Thank you, sir.
Just one question. It's your position that the 2013 amendments abrogated Connor's requirement that CADA cases are not subject, or holding that CADA cases are not subject to the CGIA?
I think that those amendments added a new claim, a new tort claim that lies outside of the scope of the holding in Connors. And we cited in our opening brief, Friedland, the case that says when there's been a change in the law, courts need to take that into consideration. That's my take on that. I don't know for sure whether they were looking specifically at Connors. I have to think that they should have been aware of it. Whoever drafted that statute clearly added provisions in there expressly about the CGIA.
Did you find any legislative history indicating the purpose of the 2013 amendments was to, in effect, abrogate Connors?
I did not.
Mr. Johnson, you have 3 minutes for rebuttal. You have 17 minutes, Ms. Archer. I'm sorry. What? Did I add wrong?
No, go ahead.
You have 17 minutes.
Good afternoon. My name is Marilee Archer from EEO Legal Solutions, and I represent the plaintiff, Brent Houchin. Preliminarily, I want to thank the panel for recognizing the true public impact of its decision here today. Because Denver Health today lays claim to an exotic legal species status as a public entity created by statute, a status that would also be impacted if it were a special district, if it were a school district, if it were any kind of local government. So the court's decision here today not only impacts the 500 or so LGBT employees at Denver Health, but also the employees that work for other state and public entities created by statute that are not technically agencies of the state. Since 1957, Colorado, in one of the first states to outlaw discrimination in the Colorado Anti-Discrimination Act, we've recognized that when employers focus on common traits instead of individual talents, that is not just a personal injury, that is a societal injury. And so when the Colorado Anti-Discrimination Act was passed in 1957, and then with Title VII of the Civil Rights Act of 1964 and 1964, we knew that the purpose of these statutes was not simply to recompense people who'd been victims of discrimination, but to stamp out a pernicious practice that is really a societal injury in two fundamental ways. And I believe the court's decision in this case provides an opportunity to clarify that. Discrimination isn't just a personal injury, it's a societal injury because it is, first of all, an act of economic violence against an entire group of people because of their common traits and not their individual talents. Their common traits like the color of their skin, their ethnicity, their gender, and yes, who we are and who we choose to love. In 2007, the Colorado General Assembly added lesbian, gay, bisexual, and transgender status to the list of protections because when employers discriminate based on these traits, based on our race, based on our LGBT status, they are preventing an entire community of people from competing on equal footing in a competitive Colorado economy. But discrimination is a social injury beyond that, and even more pernicious, and we've known this for well over 50 years. Because when employers act on the basis of common traits instead of individual talents, we all lose. The whole community loses. We lose the ability to benefit from the talents of a talent-rich community, and we need those talents to help us solve our most pressing problems.
Mr. Archer, let me interrupt you.
Thank you, Your Honor.
The COTA was amended in 2013. So the General Assembly, and they added sexual orientation as one of the protected classes, too, at some point. So the General Assembly clearly accepted the argument that you're making now about the need for the Colorado Anti-Discrimination Act. The question, though, is as it relates to the Colorado Governmental Immunity Act, your counterpart, Mr. Johnson, made a point of saying he wasn't aware of any case where compensatory damages are available and not subject to the CGIA. Are you aware of any case?
Well, yes, Your Honor. I mean, in fact, even looking at the decision since the effective date of HB 1136, which was enacted in 2013, took effect on January 1st, 2015. If we look at that, we can see two cases since then that were cited in our brief where the availability of compensatory damages and punitive damages against a governmental employer did not hinder their ability to recover the damages that were intended by the amendments to the remedial scheme 2434-405. See, we agree that this is a matter of statutory interpretation. What was the legislature's intent in 2013 when it legislated these remedies into the statute? And so what we submit to you is, and this goes to your question, Judge Berger, is that we believe that what the legislature was trying to do is harmonize principles of liability with governmental immunity to say we want governmental entities to be liable for unlawful discrimination because we can't tolerate pernicious discrimination in governmental entities.
Which are the two cases you just made reference to?
Sure, Your Honor, and I believe that this is one of the cases in which you wrote a very thoughtful dissent, Williams versus Department of Public Safety, and then since then, United States Magistrate Kathleen Tafoya recognized in Knopflin that because of the purposes, the inherent purposes of the Colorado Anti-Discrimination Act, regardless of the relief sought, that those compensatory damages would be available. What Denver Health wants to do is focus on a remedial scheme.
For a second. So these cases say, I recognize that there were compensatory tort-like damages available and said, and so they were not found to be subject to the CGIA?
These are two decisions interpreting the Colorado Governmental Immunity Act in the context of the 2013 amendments to the remedial scheme of the Anti-Discrimination Act. And so what I'm pointing the court to is two opinions in the aftermath of these 2015 amendments that recognize the inherent purpose of the statute was not to recompense individuals, but to eradicate discrimination. Your Honor, there's nothing logically inconsistent about a remedial scheme that seeks to eradicate pernicious discrimination on behalf of a community and behalf on social goals that also seeks to make whole individual victims of those unlawful employment practices. I mean, I hear Denver Health saying that almost dichotomously and illogically that if the purpose has to be one or the other and cannot be both, and I submit to you that this has been true under Title VII for over 50 years, that statutes can perform two purposes: eradicate unlawful discrimination while seeking to make the victim whole from those practices. As Mr. Johnson conceded, however, even if my client only were to seek equitable relief under the statute, according to them, there would still be absolutely no remedy for unlawful discrimination.
Well, I don't think Mr. Johnson is claiming that the statute can't have two purposes. All he's claiming is that the way the General Assembly wrote the amendments in 2013 is it subjected these claims to the CGIA. That's what his argument is. I don't think he's talking about whether these statutes aren't good statutes, whether they don't advance social goals. He's just saying, I read what the legislature wrote in 2013, and what they wrote, the effect of what they wrote, is that the CGIA, for good or bad, applies.
What he's saying, Your Honor, is that because of enhancements to the remedial scheme in 2013, that it instantly transformed the Colorado Anti-Discrimination Act into a tort. Even if he only sought equitable remedies, he's saying that by virtue of the inclusion of those remedies under Connors, it transformed this statute that serves social purposes into a tort because it could be money damages for which they enjoy absolute immunity. And what I'm trying to say is that the legislature made very clear in trying to harmonize Provision 8G with Section 3G Section 3B1, which expressly immunizes the state and other public entities like Denver Health from punitive damages. And I ask the court, as a matter of logic, why would the legislature immunize public entities from punitive damages if it did not intend for them to be held liable for unlawful discrimination in the first place?
Well,
That fails as a matter of logic, because it could have.
I don't think that's what Mr. Johnson's argument is.
Indeed it
He's
is.
saying that if you're an agency of the state under 8G, the agency is liable. It's just that his client, for whatever reason the legislature did this, I can't frankly conceive of the reason, but they decided that only state agencies themselves would not be covered by the CGIA. That's his argument. The language that the legislature enacted provides some support for that.
Your Honor, as a matter of logic, and try to come with me here, is that if you look at the language in 3B1, it expressly says that governmental entities like Denver Health, special districts, school districts, any other public entities are insulated from punitive damages. It doesn't make sense that the legislator would have sought to protect these public entities' treasuries if it did not intend for them to face liability in the first place. And if you look at the legislative history that Denver Health has asked the court not to look at, that's exactly what it says. I cited to a fiscal report, did a deep dive and looked at the legislative history, and that's exactly, almost contemporaneously with Governor Hickenlooper's signing of this bill in May of 2013, it says, we expect local governments like public entities, special districts, Denver Health, to have an uptick in LGBT discrimination claims, but because their treasuries are insulated from punitive damages, it's not anticipated to have a heavy or burdensome fiscal impact. And so that, it was, in the plain language of the legislative history, the intent of the legislator in trying to harmonize principles of liability while again protecting state treasuries from.
Who's the author of that? I mean, some would say there's no such thing as the plain language of legislative history, but that's.
One of the curious and illogical things to us, Your Honor, is that.
But who authored that? Who wrote that?
Who wrote the bill?
No, this fiscal note that you're talking about.
It was certainly a member of the legislative staff. That's how it works. That's part of the legislative history. When you argue cases in state court or federal court, that they conduct contemporaneous notes based on the concerns of the legislatures. And this is what the point that they were trying to drive across is that, yes, local governments are going to face LGBT discrimination claims, but they're not going to be subject to punitive damages to insulate their treasuries. What deeply concerns me about this is this claim of an exotic animal status that has absolutely no liability under the Colorado Anti-Discrimination Act or the State Employees Protection Act. Now, for all intents and purposes, Your Honor, that is moot because the trial court dismissed it for lack of CGI notice. We did not appeal that because it did not affect our presentation of evidence nor my client's damages. But again, when we have a state agency laying claim to a status that entitles it to all the immunities, but none of the liabilities facing other governmental agencies, we need to be concerned because these perceptions of immunity breed noncompliance, which is what has happened here.
Ms. Archer, how would you distinguish the Lloyd case? There, the Colorado Supreme Court was looking at the nature of the injury and the relief sought. It was a retaliation claim, and they ended up concluding that you would have to go through the CGIA, right?
under the Lloyd case, and I don't know, based on the circumstances, the current posture of the appeal, Your Honor, that I would distinguish it. As you know, Lloyd was a SEPA case, a State Employees Protection Act case. And so, as Judge Goldberg noted, we are in this box where we know that the wrongful discharge in violation of public policy tort is barred by the Colorado Governmental Immunity Act, which is one of the common law claims they can assert when they assert that they have been terminated because they have raised important regulatory issues, as in this case, ongoing drug diversion at a publicly funded hospital. But what would happen, as Judge Goldberg pointed out, if you conclude, either based on the Lloyd case, that SEPA is a tort barred by CGI immunity, or if you buy Denver Health's argument that it is not even an employer because it is not an agency of the state, then what you have is a state agency, Denver Health, where employees are bereft of any remedy for coming forward to report things that are squarely within the public interest. And as I've pointed out, the legislature has twice since 2013 made enhancements to the State Employees Protection Act to encourage employees to come forward and blow the whistle about unlawful practices that squander public resources and subject the public to drug-addled service delivery at a public hospital. And so I would distinguish it as the same way Judge Goldberg did, is that it would reduce SEPA to a legal nullity to rely on Lloyd and divest employees of the state's biggest public hospital of any remedy they may otherwise have for coming forward and reporting dangerous practices.
It's very troubling that if the legislature intended to draw this distinction that Mr. Johnson claims, it's troubling. But your arguments seem to be all policy arguments that are more properly addressed to the General Assembly, not to a court. We have to construe and apply the statute. We don't get to say, well, it'd be nice if the legislature did something different than what they did. That's just not our role.
The task before the court today is to breathe life and give meaning to the legislative intent. This directly involves what the legislature intended. Now, we have to resort, Your Honor, to rules of statutory construction because I would submit to you that the language is not clear. But if the language were clear, we would not have much to do all day. We are attorneys submitting to you two interpretations of a statute where the language isn't clear, and so the next place we go is to the legislative history to divine what that legislative intent was. And so we can't simply say the language is ambiguous, perhaps Denver Health is right, when we have so many tools before us at this moment to understand exactly what the legislature was trying to do and the societal goals they intended to fulfill.
Thank you very much. Mr. Johnson, you have 3 minutes.
Judge Roman, you asked Ms. Archer whether there were any cases that supported her position, and she referred to the Williams and Knopflin cases. Neither of those cases addressed the expanded tort remedies under the 2013 Act. We had addressed those cases at pages 4 to 6 of our reply brief. I urge you to read that. They're not on point at all. Judge Berger, you asked who wrote the fiscal note that Ms. Archer relies upon. It states on the fiscal analysis that it was written by fiscal analyst Claire Pramuk. I looked her up under LinkedIn, and she's got a BA in radio, television, and film, and an MA in political economy. Now, that's not in the record, but it goes to illustrate the danger of relying upon legislative history. And the Supreme Court has said, we don't look any further if the language of the statute is clear. None of the language in the statute is ambiguous. This is not like a case where the court has to construe what is or is not a motor vehicle. Judge Ramon was a concurring decider on a case regarding that not long ago under the CGIA.
Mr. Johnson, let me ask you this. If we go your way, doesn't it inevitably raise very serious equal protection claims? In other words, why in the world should an employee of Denver Health, who, Denver Health, as I understand it, is a political subdivision of the state of Colorado, why in the world should an employee of Denver Health be treated differently in terms of employment protections than an employee of the Colorado Department of Revenue?
Because the state employee is subject to that provision in the statute. And Your Honor, going back to your question whether that's an exemption or a waiver, and
Well,
even
just,
if,
could you just answer my question about, wouldn't that raise very serious equal protection
I don't
claims?
believe so, Your Honor. I think the constitutionality of the CGIA has been addressed by the Colorado Supreme Court. That same argument could be made as to any kind of claim that is allowed as to a private defendant but barred as to a governmental defendant. In Evans, the Colorado Supreme Court said, we abrogate the common law doctrine of sovereign immunity. We are getting out of the business of looking at public policy and deciding what claims there should be immunity for and what claims there should not. And so Ms. Archer's public policy arguments are not ones that this court should decide this case on. It's up to the General Assembly to make the policy decisions about what claims are immune or not immune. They recognize the potential applicability of the CGIA. They could have easily added a provision that says the CGIA immunity is waived as to all public entities. As to the provision about the state, whether it's a waiver or an exemption, and you suggested that the exemption would mean that notice wouldn't be required, that would still only apply to the state. The state is not allowed, so that would affect whether the state has a right to receive
Your time is up,
notice.
Mr. Johnson.
Sir.
Thank you, counsel, for your excellent arguments. The case is submitted. We will issue a written opinion in due course. That completes our docket for this afternoon, and the bailiff will please announce a recess.